All right, super. So thank you all that are on and appreciate this. If you did not attend part one, that's okay. You have some great information for part two. If you did attend part one, we thank you for coming back for the second set of series here. Ryan will be taking over here shortly, and any questions that you may have during the chat, during the webinar, just type them into the chat box, and we will address them upon receiving them. So let me introduce Ryan Reister. He is been our FAMP attorney and a friend of FAMP for a number of years. Ryan has been at the forefront of representing mortgage companies of all sizes for over a decade. Ryan founded Reister Law in 2008 in order to utilize his years of experience in the mortgage industry to assist mortgage companies and trade associations. Since beginning his legal career in the mortgage industry, he has gained a deep industry understanding, which keeps his clients informed, compliant with regulations, and conducting business. In addition to his extensive mortgage industry experience, Ryan works with a variety of businesses, including trade associations, nonprofits, startups, and political action committees. In his tenure as outsourced general counsel for multiple entities, Ryan keeps clients informed of current legislative and regulatory issues in their industries, preparing them for impending law changes. He's highly regarded for skills in public policy, legislative relations, and government affairs. No matter what the issue is, Ryan and his team always deliver superior advice and creative solutions to help their clients thrive, which I will give a testimony of that absolutely. So Ryan, the floor is yours.
Thanks, Linda. You, as always, are too kind. Hopefully I can keep everyone's attention and live up to the expectations Linda set with that readout of my bio. But as she mentioned, this is part two in a series, and it's actually going to be a three-part series. We're still working on finalizing a date for part three. So if I don't bore you to death today, I'd love to see you in part three, where we'll kind of build upon what we talk about today a little bit further. In case you weren't here for part one, or it was a month ago, just a quick recap. We really focused on these 5 subject areas: is starting a business right for you, what's involved, setting expectations in terms of costs, timelines, managing your existing obligations, and then really putting the right foundation in place and the right framework for your entity, for your mortgage company. So from choosing the right business structure, drafting your organizing, governing documents, and then really preparing for your transition to business ownership. So today we're shifting gears a little bit to what I'm going to phrase as protecting your company, protecting your new business. We're going to focus on some of the key areas that, while still very much related to being in startup mode, are starting to get more at your operations. And how you're able to protect what you've created. So we're going to talk about your company licensing and a little bit about branch licensing, just to walk through that process for anybody who is maybe doesn't have their company established yet and is still looking to do that. We're going to talk about protecting your business with the right insurance. I'm not an insurance salesman. I do not get any kickbacks from any insurers. But we're going to talk about it anyway because it's very important. It's something that, in my experience working with small businesses all across the country, is often overlooked in one way, shape, or form. Most everyone knows they need some insurance, but virtually every business is underinsured. We're going to talk about hiring employees, the considerations that go into that, and some of the thoughts and tricky areas that you want to think through ahead of time and make sure you cover your bases on if you do go that route. We're going to also talk about your policies and procedures. We're not going to be able to do a super deep dive into anyone, but we'll talk at a high level about what policies are absolutely required under the law, what policies are certainly a best practice, and also provide some insight into at least my view on the critical components of those policies. We'll talk about reviewing and negotiating your broker agreements. This is a subject that comes up a lot in my practice. I talk with clients, and when I'm traveling to conferences and events, this is something that comes up in conversation with brokers often is, what, I don't understand these broker agreements. I don't even bother reading them because I don't think I can change anything. So we're going to talk a little bit about, the truths and the myths around that. Then we're going to talk about understanding your technology and your software as a service agreements, basically those other third-party agreements that you're entering into for your support systems, because they are still contractual, but they're very distinctly different from your broker agreement. And there's a few nuances that you want to pay attention to there when you're signing up with service providers in the tech space, particularly. I can't say anything about myself that Linda didn't already. The obligatory disclaimer: everything that's being shared today is just information. It's not legal advice. We aren't forming an attorney-client relationship here. I strongly advise that if you have specific questions about your business, feel free to ask your questions today. I will be glad to give you information. If something is going to require more specific answers tailored to your situation, you really need to contact your private attorney. There are a number of great attorneys that operate in the mortgage space, and most of them are extremely helpful and generous with their time. So if you're not working with one, again, it's not a requirement, but it's highly advisable because of the complexities of running our business. So let's get into the meat of it, what we're going to talk about today. We'll start off with company and branch licensing. We touched on this briefly in the first part of the series. And so we're going to take a little bit of a deeper dive into the specifics of how to get your company license, because again, that's the essence of this series, is starting your own mortgage company. So you see, one thing I always like to start off with is licensing your company is not something you need to be afraid to tackle yourself. There are third parties out there, extremely good companies and extremely helpful ones that will walk you through it, will take care of it for you completely. And there's nothing wrong with going that route, but you shouldn't be afraid to take it on yourself. The NMLS, whatever you think about them as an organization, their customer service, in my experience, is really good. And so in terms of walking through the actual process of filing your MU forms, navigating their system, working through any issues you have there, that's something you can do by yourself. I always, make sure my clients understand that this is not something you need to pay for. You certainly can. And if you're scaling your business, for example, to multiple states, that's when it may become more cost effective for you to continue focusing on originating loans and let someone else take care of the back end of the licensing piece. But again, just starting out, it's something you can certainly tackle yourself. The Office of Financial Regulation is also extremely helpful in Florida. And so questions about licensing, they'll be there to answer them for you, as are most state regulators that I encounter, particularly on the licensing side. The clients that I worked with, even if there are small hiccups or questions about documentation or things, they're usually pretty responsive and able to work through those with you. So again, don't be afraid to tackle the licensing yourself. There's three types of company licenses in Florida: mortgage broker license, mortgage lender license, and then a mortgage lender license with servicing endorsement. For our purposes, we're going to focus on the mortgage broker license today. There's not a ton of difference between the three, but if you have any questions about lender specific licensing, that's something, feel free to send a note in the chat, and we can connect offline. And then those are resources that FAMP can help with as well. So we're also talking about branch licensing, and we'll touch on multi-state licensing, although we're going to go deeper into that in part 3 of our series. So to operate as a mortgage broker in the state of Florida, you need to have a mortgage broker license for your company. We talked in part 1 about the necessity to have your individual loan originator license first, and to have a year of experience so that you can be the qualifying individual principal broker. You choose your favorite terminology there. But in order to start your company, that's really the main prerequisite, is that you have at least 1 year experience as a licensed loan originator. And then it comes the technicals of filing. So you file an MU1 and an MU2 for each of your control individuals with NMLS. There's an application fee and a processing fee. It's important to note, I think anybody who's worked through the NMLS with their own individual licenses probably know this already, but anything you pay to NMLS is non-refundable. So make sure you're ready to go and committed, or aren't particularly attached to your roughly, $575 or whatever it is, because they do clearly remind you that it's not refundable. But so $425 application fee, $100 processing fee, not a huge barrier of entry, which is nice for starting out, because there's plenty of other things that require outlays of cash when you're getting started. As you see the note there, when your qualifying individual, your control person for the entity is an active Florida loan originator already, you get to bypass the state and a federal criminal background check and credit report. It's also extremely important to note, we talked about timing in part 1 of the series in terms of filing for your company license. In our last webinar, we talked about, you really don't want to file a new application during renewal season, because the OFR is so swamped with renewals, the processing times are going to be delayed. And that's not unique to Florida. That's every state across the country. And so if you really need to or want to start your business in the fourth quarter of the year, that you have to prepare yourself for a little bit of a delay, more so than if you started it, for instance, now. But the OFR will not begin reviewing your application until they've got all of the information. And that's pretty true for every state regulator if you are getting licensed in multiple states. So it's important to have yourself organized, have your ducks in a row, as I always say, and just put everything in there together once. As long as your application is complete, then they will at least begin to review it, and the dialogue will start between the regulator, in this case the OFR, and you, if there is any deficiencies with anything, and if they need any clarification or additional documentation. So, but the key is to submit a complete application right away. The license for your company is all you really need to become operational. So once that's approved, you're good to go. You will need a branch license if you're going to operate it out of multiple locations. So with your primary license application, you're going to identify a principal office location. That's going to be, your headquarters. That's going to be where you conduct, your business. That's going to be the address that's associated with your company. So it's very easy in 2023 to look bigger than you are if you want to, and to expand, quote unquote, through virtual office space and different things. Some people spend time in different parts of the state or in different states at different times of the year. And so you may end up deciding you do want to operate out of more than one location. If that's the case, you do need to file a branch license application. You can see slightly reduced application fees. You do need to designate a branch manager, but again, fairly simple, straightforward process. This needs to be filed for any additional locations that you operate from other than your principal location. It's that's not to say if you're working remotely for a day or a week when you come to convention, that's not what this is designed to cover. It's designed to cover a physical location that you're holding yourself out as offering mortgage origination services from, or using on your business cards, basically any kind of consumer facing information about that office space. That makes it a branch and something that you would need to register with the OFR. So that was kind of the licensing piece. Like I said, we're going to dive deeper into some of the multi-state licensing. I don't want to say issues, but just things to be aware of, challenges, opportunities there in the third part of our webinar series. This is again focused more on getting everything up and operational and going. So just limiting, for time's sake, the discussion to initial company and branch licensing. Now we'll pivot to a little bit of a discussion on insuring your business. So protecting yourself with the right insurance. As I mentioned at the top, most businesses, I would say, I don't think I'm going too far on a limb by saying most small businesses across the country, and certainly many that I work with, are underinsured. And that's not to say they're not insured to a high enough dollar amount. It's that they tend to not have the proper net or network of insurance coverage to protect all of the different pieces and parts of their business and their people in the case of having employees. So this is a long list. We'll touch a little bit on some of the specifics here and there, why they're each important. General liability policy, that's what most business owners have. Sometimes you'll see it, depending on which insurance companies you work through, they'll offer a business owner's policy, which is a combination of some of these, but almost never all of them together unless you ask specifically for it. But a general liability policy is something that most small businesses do have. It's necessary. You want to be covered. You want to make sure it includes an agency endorsement if you have employees working for you, because then if there's any harm that they cause while they're working for your company, that general liability coverage will extend to their actions in that situation as well. Professional liability insurance is another one, also often referred to in our industry as errors and omissions. This is the other one that most mortgage companies have. Most everyone knows about and makes it a priority to invest in. Again, it is not optional in my view. You need to have this. It's extremely important to protect yourself. It's also important to shop around for errors and omissions coverage, because it's not all E&O insurance is created equal. There's a lot of things that will be excluded from coverage that you would like to have covered. And so it's worth talking through with your insurance agent, your insurance advisor, your attorney, to review the policy documentation and make sure it's got the critical components you need, that you're not going to be facing a going out of business proposition, for instance, in the case of a buyback situation with a loan. And we're going to talk more about that and other ways you can protect yourself through the broker agreements when we get a little bit later on in the presentation. But errors and omissions insurance is necessary and is important. And for those of you that joined part one of the webinar, you heard me discuss, and you probably hear me reference it again today a few times, is I'm a big believer in having the right team around you. I think it helps any business owner to have the right advisors, have an attorney, have an accountant, have an insurance agent or insurance broker that you trust, that you can have open conversations with and ask questions about. Hey, do I need business interruption insurance? Do I need to separately insure my business equipment from my, what might be required in my office lease? Those are the types of questions that you need to have answered and need to think through. And that I'm going to use that as a segue into some of these other bullet points here. But business interruption insurance is something that most businesses do not have. I think you're seeing an uptick in an understanding of this and in the purchasing of this post-COVID, because so many businesses were impacted so severely by government shutdowns, and by employees who were laid up with illness during that time. And so business interruption insurance is something to look at and to consider, especially if your business is your sole or your primary source of income. Business interruption insurance is also extremely important in a state like Florida that faces natural disaster threats on an annual basis. And so it's something worth considering, worth talking with your insurance advisor about investing in. Commercial property insurance, if you are leasing office space or if you own your own office space, obviously you're going to need that space to be insured, but you're also going to want to make sure it's either included in that policy or a rider with that policy that your business equipment is insured, so that if there is a fire or a flood or some other catastrophe that happens to your office location, that you're not left holding the bag for replacing all of your hardware, all of your computer equipment, and any other physical business equipment that you own. Workers' compensation insurance is required if you have employees, and that's something that you don't want to overlook because of the penalties and risk involved in not carrying that. Commercial auto is often overlooked. That's something that most people are like, well, my business doesn't own a vehicle. We're not, a landscape company. We're not driving around in trucks or anything like that. But you want to make sure that somewhere within your network of insurance coverage, you and your employees are covered in the event that an auto accident happens while you're driving to a closing or while you're going to meet with a customer. Because while you're on the job and using even your personal vehicle, or your employee is using his or her personal vehicle for a business purpose, some personal auto insurance policies will exclude coverage there. They'll say you were using this vehicle for business, and that's not going to be covered. And you also, again, if it's your employee, having that extra layer of coverage is a benefit that you can say, okay, you were unfortunately caused an accident or in an accident while you were on business for my company. we've got this covered under our policy. A hugely important one, and again, is more and more people are taking note of and investing in is data breach and cyber liability. It's called different things. You'll see it referenced as one or the other, sometimes both, depending on your insurer. But everything is so digitized now, and more as mortgage brokers, as mortgage company owners, there's so much consumer information, personally identifiable consumer information that is valuable to criminals, that is valuable to people that want to use it and exploit it for their own means. And so mortgage companies are big time targets for hackers, and having some type of data breach coverage, cyber liability coverage is almost required at this point. And I use required with a small r. Obviously, you're not required by law to have that, but it is getting to be the point where it's particularly negligent if you do not have coverage. And the nice thing about this is most of these insurers that are offering this, either directly or indirectly through a partnership that they have with this cyber liability coverage, will come, the disaster recovery piece, and they'll have consultants and advisors that are either on, connected with them or are going to be paid for through the policy coverage. So it's really, it's impactful enough if you have any type of a security incident, a cybersecurity incident. Not having coverage is, very frightening. I've worked with clients who've, and it never fails. It always happens on like a Sunday morning or on a Friday at 11 o'clock at night. And so knowing that you have a little bit of protection just gives you that added peace of mind that you're not going to hopefully be down and out of business for a long period of time, and that your data, if it can't be recovered, at least you'll be compensated for the loss there. Employment practices is another one that's only really going to come into play if you have employees. It's important to think about. It's often overlooked. That is going to cover you for things like wrongful termination. Most people are like, I don't need employment practices. I'm not going to sexually harass anybody, or I'm not going to discriminate against anybody. That's true for the vast majority of people I work with, but it doesn't stop allegations from being made. And so having the coverage is, again, another layer of protection and insulation. But really, the wrongful termination piece is one that, even if you believe you're doing everything right, trying to do everything right, that's a claim that you do see, fairly often in our industry and across all industries. And then you might hear something called a commercial umbrella policy. It's something that I just throw in there for a kind of a definitional terminology piece. That is, generally speaking, something that will be offered to enhance your coverage, the level of coverage you have across all of your policies. And so if someone's trying to sell you on that, that's usually what that means, but always take a close look at that and decide whether you really need that or not based on, the size and scope of your particular business. So that was a lot, especially on insurance. And I know people just love listening and talking about insurance. So I'll pause for a second if anybody has any questions to this point, and I'll take a sip of water, and then we can proceed.
I do not see any questions in the chat box yet. So, but I was going to ask you a question on again, the business insurance, loss of business. Is that, as you said, that's becoming more and more popular?
It is.
After COVID?
Mm-hmm. Yeah, insurers are more aggressively offering it because people realize what that impact is of lost business. But more businesses are opting into that as well, because if something happens and you're shut down. Now, the nice thing in our industry is, as you guys all know, you're capable of continuing to work. If there is a fire, a flood, a hurricane that maybe wipes out your office or forces you to evacuate for a period of time, it doesn't mean it's impossible for you to work. And so that's something you need to weigh. But on a larger scale disaster, it's something that people are considering, because if it is your sole or primary source of income, that can be devastating to be even down and out for a couple of weeks or a month or more.
Well, I think especially for small brokerage shops, that would be truly something you'd want to have as a backup. So
and that's something too we'll touch on again a few slides from now in terms of policies to put in place. But business continuity policy is something that is being talked about more and more frequently. And so a lot of these things that we're going to talk about today, they do fit together. There is a bigger puzzle that hopefully you'll see as we continue to go, that these pieces do kind of all fit in place. So the insurance may be less important if you've got a structured plan that you know you can follow and activate immediately. It may be more important if you haven't put the time and energy into putting that plan in place so that you can stay operational in a remote capacity. But again, like I said, our industry, we're fortunate that we can do a lot of things remotely. We're very technology based now. And so it's not maybe as critical as it is in other industries.
Exactly. Okay, we do have a question here. Going back to the multi-state licensing, in order to obtain a license in another state, does the company need to be licensed or the mortgage broker or both?
Great question. Both will need to be licensed to do business in other states. So, and the nice thing is, I can't say with 100% certainty all 50 states are like this, but usually you can apply at the same time for your individual and your company license, and they'll process them together because you're tied to the license as the qualifying individual. And so it can be reasonably efficient in most places, in most states, again, depending on the time of year you file, but you will need your company to be licensed or registered as the case may be, and you'll need to have your individual license in that state as well.
Okay, great. All right.
And like I said, we're going to dive deeper into that topic in the next part, but I'll also add, if you're already looking at multi-state licensing and thinking about it, it's important to be prepared for there to be different requirements in the different states you go to. So Florida is, I call it a pretty friendly licensing state. It's not overly difficult to get licensed in Florida. You don't have some of the requirements you have other places. If you go into other states, you may have to show financials with a particular net worth. You may have to get a surety bond of a particular amount, among other things. And so it's just something to be aware of in terms of when you're putting your application together. Don't assume that everything you did in Florida, you just submit to, Georgia, West Virginia, South Carolina, Texas, and it's going to go through. It might be deemed incomplete if they need something else.
Okay. All right. Good to know. All right. This is a very interesting start here. So I'll let you take it away and explain it.
Yeah. Well, I'm boring enough. I try to at least throw something interesting or cute in the slides. So the question of, do I not hire employees? And so that's why I phrase it, are you more of a lone wolf or do you like to hunt with a pack? Either way, there's nothing wrong with either way. I'm talking to you as a true solo practitioner myself. And so that's not to say I'm never going to decide I need to hire or want to hire employees, but I understand the motivations and the desires for those of you that maybe want to just go it alone as a solo shop. But I also understand, the efficiencies that come from having a staff that can help support what you're doing. So it's a personal question that everyone needs to ask themselves and to evaluate. But while you're doing that, while you're thinking through, okay, do I want to go it alone or not? Here are some of the key employment related issues that I always talk with clients about, really giving adequate thought to on the front end. So do you want to add loan officers? Do you want a sales team so that you can, build out your business that way, generate your revenue? There's pluses and minuses to that, as all of you probably know. With the sales force comes additional opportunities to generate revenue for the business, but also is an extension of your liabilities. And so your risk exposure becomes greater as you have more people working for you and out there representing your company. Maybe you just want or feel you need support staff to help you be a more efficient loan originator. You don't necessarily feel the need to bring on other LOs to sell or to write loans, but maybe you need some processing help. Maybe you need someone to answer the phones or to staff the office so that you can take the walk-in business. A lot of this is going to be really dependent on just the nature of your business, how you plan to operate it or how you do operate it, and your level of comfort in terms of, again, going it alone or having a pack around you. Whenever we're talking about employment issues and hiring employees, hiring staff, the question comes up about classifying employees properly. And there's two classifications that you need to think about. The one, which is always hotly debated, and we can talk in detail if you guys have some specific questions, is the W-2 1099 divide. So true employee versus independent contractor. The other classification you need to be aware of is exempt versus non-exempt. And when we refer to exempt and non-exempt, what we're talking about is their minimum wage and overtime requirements under state and federal law. So in general, you're required to pay your employees minimum wage and overtime, unless they fall under one of the exempt categories. And there are a number of them. In the mortgage industry, really, it depends on the job function in terms of which classification might apply. In small businesses, you tend to not be able to meet the executive classification, except for if you're the owner. Larger companies, larger corporations will have larger executive teams that would meet that classification. The administrative exemption is another one. That's one that you will see applicable in a small business setting in our industry, particularly in terms of if you have a receptionist, if you have like a loan officer assistant. A processor is most likely not going to fall into that category, but under the specific circumstances, it's possible. This is one of those areas, and you'll hear me say this probably too many times, but it's very fact specific. And so this is one where having, really an attorney that can help advise you and look at the specifics of your employees and the job functions that they're performing, to help you determine whether they're exempt or non-exempt. And then with loan officers will only fall under one exempt category, and that is the outside sales exemption. That is not a particularly difficult exemption for a loan officer to satisfy, but there are very particular requirements you have to put into place and make sure that both you and your LO understand and then operate within those confines. And so I'll talk about it for a little bit here. So I probably could have done a slide on this, but I should have. But I'll just talk about the outside sales exemption is something that a lot of mortgage companies aren't aware of and aren't utilizing, in my experience. So a number of my clients do utilize it because we've talked through the issues and they feel comfortable with where we're at. It is we do not have a bright line test that tells us, yes, you're an outside salesperson if you do X, Y, and Z. No, you're not. It's a gray area. And so, but we have some pretty good guidance out from a federal district court decision out of the Eastern District of Virginia. Now, full disclosure, that's not great precedent because it's not binding anywhere outside of the Eastern District of Virginia, but this is not an issue that's been directly tackled by any other courts. And so this is a case that I personally look to and that my colleagues I know look to and say, all right, this is instructive of how at least one federal court viewed this. And so if we operate generally around those parameters, I have a comfort level talking to my clients in terms of their compliance with the outside sales exemption. So the crux of this is, and this is where I can't get into too much specific detail, but the crux of it is, if you're a loan officer that's out in the field, that is not sitting at a desk, taking calls, basically operating as a call center. If you're out going to closings, meeting with customers and clients, attending open houses, meeting with referral sources, really the way I describe it is doing a lot of the things that really good LOs do anyway. Generally speaking, you're going to be more often than not close to qualifying as an outside salesperson. And so that's something, if you are building out a staff of LOs, it's worth looking at. If they're out generating their own business, generating their own leads, they very well may qualify as outside salespeople for your company, which would exempt them and you from having to pay minimum wage and overtime. And so they can be on a straight commission model, which is, in my experience, what most broker owners are looking to do if they can. But many feel that many aren't aware that that's even a possibility, which leads me to the second part of this, which is the 1099 W-2 debate. So this is where I see, unfortunately, a lot of people in our industry get this wrong. In the interest of paying commission only, instead of understanding and pursuing the outside sales exemption, many business owners immediately classify their workers as 1099 so they can just pay them straight commission and not, quote unquote, worry about any of the other stuff. This one's very simple for me. I say it's hotly debated. It's not debatable in my mind. There is no way that you can compliantly pay a loan officer 1099. It doesn't work. I can't point to any black letter law, rule, regulation, or otherwise that says it's prohibited, because it's not. But the reality of the classification is that you have a convergence of common law, Department of Labor regulations, and IRS, Internal Revenue Service regulations, and a state law component as well, in terms of how an individual is defined as an independent contractor versus an employee. Almost universally, there's a presumption that a person is an employee that you as the employer need to be able to rebut when you're hiring an individual. And with LOs in our industry, it's just not realistically possible. LOs necessarily have to be tied, like your company sponsors their license. That creates a control situation that really doesn't jive with any interpretation of independent contractor. LOs are also critically essential to the operations of a mortgage company's business. And that also is another factor under virtually every common law test in terms of determining independent contractor versus employee. And those two factors alone skew so heavily in favor of classifying LOs exclusively as employees, as W-2 employees, that the remainder of the test, I mean, I consider it almost an exercise in futility to go through, all the 10-point tests, or to really highly scrutinize all those pieces and parts. I've had people ask me to do it. I've done it for clients, and we keep coming to the same answer. It might be possible someday, under some very fact-specific scenario, that a company compliantly categorized its LOs as 1099 independent contractors. I've not seen it. I've spoken with many regulators who say the exact same thing, that they've not seen it, and they're not convinced they'll ever see it. But again, it's not black and white. That's why it's always going to be a debate that comes up. But I will tell you, don't classify your LOs as 1099 contractors. It's a recipe for trouble and potentially disaster for you down the road. So that's a little bit of a soapbox thing. I don't think it's, in my experience, I don't see it as an issue really in the state of Florida. Most of my interactions with brokers and lenders in Florida, everyone's pretty much W-2. There's still an undercurrent of conversation, but there are other states where this is a heavy debate, and there's a very strong opinions on both sides. But quite frankly, the side that thinks that you can 1099 them is wrong. Registering for state unemployment, in Florida, they call it reemployment tax. This is something, again, you can't overlook. You need to check this out. I put the website up there for anybody who wants to type that in and check it out. It's got great information for you about it. In general, if you have 4 or more employees, you're going to be required to register as an employer. If you will have to count yourself as an employee, as an owner. Now, there are exemptions you can apply for to exempt yourself from executive officers, partners, if you have multiple owners of your company. But this is something you want to familiarize yourself with when you're starting your business in general, and especially if you're embarking upon, building out your staff with employees. So another very hot topic to discuss, and I'm happy to answer questions if you guys have any here, is protecting yourself, protecting your business with non-competes, with non-solicitations, with strong confidentiality provisions in your employment agreements. So as a threshold question, the first thing I always try to address is, are non-competes enforceable? This is one of those areas where people in different states, rightly so, have different views on whether they're enforceable or not. There are certain states, California for one, where they're not. They will not enforce a non-compete. It's a non-starter. So if somebody puts one in their contract, it's just a waste of ink on the paper. It's a waste of breath to talk about in California. You'll never be able to enforce it. But in Florida, they are enforceable. Courts will enforce it. There are statutes that you can rely on. And so that's something to think about. I typically don't advise clients to go the non-compete route unless they have a very compelling business interest to do so. Non-competes are difficult to enforce, and the choice to enforce it is an expensive one to make that you may not you may ultimately not want to make. And so putting it in your agreement, unless you're convinced that you're going to ultimately follow through on enforcing it, it sometimes isn't worth the hassle of trying to structure it properly, and it can really turn off your employees when they see that and you put that in front of them. And so I always recommend that we focus on very specific and detailed non-solicitation provisions in your employment agreements, as well as confidentiality provisions. With regard to a non-compete in general, just for anybody who is interested or maybe has one and wants to know about it, in the state of Florida, it has to be reasonable. It has to be narrowly connected to a legitimate interest of the business is trying to protect, and it has to be limited in scope in terms of the time frame and the geography. So 6 months or less there's a presumption that it is enforceable and it is reasonable. More than 2 years, there is a presumption that it is unreasonable. That is not to say that a 6-month non-compete can't be found unreasonable, or that a 3-year non-compete automatically will be found unreasonable. It's just there are presumptions at those two ends of the spectrum, and there's a lot of wiggle room in the middle. The geography piece is interesting too. That's one that I personally find challenging in our industry, because we're dealing with state licensure. And so a lot of times an LO may only be licensed in the state of Florida. And if that person is prevented from going to work for another company for 12 months or 18 months, they're really being prevented from earning a living, which most courts, in my experience, will find unreasonable and unconscionable, and therefore hold that non-compete provision unenforceable. So there are lawyers and there are judges that disagree about that. But then again, that's my perspective on it. That's why I usually encourage clients to focus more on let's decide what really is confidential information for your business, what's really valuable information for your business, and let's put a good confidentiality clause in the contract that we're willing to enforce. And then let's talk about not soliciting business and what that means to protect your interests, not soliciting your employees, not soliciting your borrowers, whether it's to refinance deals that they've done in the past, or whether it's to take loans out of your pipeline and take it with the LO somewhere else. Those are more effective and tend to be more readily enforced than a traditional non-compete. I'd be remiss if I didn't at least address the fact that non-compete agreements are being examined at the federal level in terms of by the Federal Trade Commission in terms of whether they're ought to be allowed at all. I personally think that we're going to see a rule that attempts to ban all non-competes. I don't think it will withstand scrutiny, but I think it's going to motivate a lot of courts, a lot of state courts to take a closer look and to be more reluctant to enforce non-competes and to shift the reasonableness of non-competes more in favor of the employee. So again, a lot of reasons what I'm going to say is think carefully before you go down the path of bothering with a non-compete, but there are still very important, legitimate ways to protect your business interests. I think we've got somebody popped up in the chat.
We do. It says to clarify, the outside sales exemption for W-2 LOs from minimum wage, overtime, et cetera. So the outside sales exemption, does that apply for W-2 LOs from minimum wage, overtime, et cetera?
That is correct. If you have a W-2 employee who is a loan officer in this case, and that qualifies for the outside sales exemption, you would not have to pay them minimum wage or overtime. You could pay them straight commission.
Okay. And if so, if you want as close to 100% commission as possible, how little hourly could you realistically get away with?
Well,
in other words, if you pay them on 100% commission, do you have to pay hourly as well? And
not if they're an outside
minimum
salesperson. If they don't qualify as an outside salesperson, you will need to make sure that they are at least compensated to the level of minimum wage for the hours that they work. And so this is challenging for small businesses.
Mhm.
One example of a way that I've seen businesses approach this, I'm not going to endorse it or tear it apart like I might some other things, but it's just an example of a way I've seen businesses offer a draw against future commission. so that it guarantees the employee is earning at least minimum wage or more every pay period. But as commission checks come in, the company can then recoup those advances against that. That will not work in every state based on state wage and hour laws. I have not scrutinized it under Florida law. I can't say for sure whether Florida works in Florida, but it does work in a number of states. It's still not, again, it's not ideal because of the record keeping that you're dealing with there. It's not, there are challenges. And so if you have to pay minimum wage, it's best to do that. You can pay a salary and avoid the minimum wage and time tracking, generally speaking, but then you're more out of pocket. And so that's, practically speaking, a cost benefit. If you can't get your LOs to meet the outside sales exemption, then the next conversation that I usually have with clients is, where's the balancing point in terms of the commission you're comfortable paying and making sure you satisfy the minimum wage and overtime requirements. So sometimes it means maybe fewer bips on their commission, but you're going to pay them that base salary so that you keep everything. Those are business decisions that are going to be unique to everybody, their particular situation. But that's kind of the analysis that I usually walk with clients through, is to say, all right, if they're not outside salespeople, how do we then make sure this makes sense for the employee and the employer? Because again, the issues, I guess I'll emphasize this, the issues that come up in wage and hour litigation always come up when you have a disgruntled employee. And so if you can work with your employees, yeah, this is not something you're going to get examined about. And it's not something that, the Department of Labor is going to say, we want to check out how you classified all your employees, or the IRS might, but that's even rare. Usually it's because you have an employee that says, I hate my former employer because they fired me, or I hate my current employer because they're treating me like garbage or whatever. And I'm going to file a complaint. Or their neighbor's like, you probably should have gotten paid minimum wage for the last 5 years. That's how these things come out. And so it's very worthwhile on the front end to think through, how can you set up a system, a structure, a culture where it reduces the likelihood of employees, trying to cause you difficulty.
I think you answered it. I think you nailed it, Ryan.
Probably several times over. I can get long-winded. So
all right, no more
right,
questions at the moment.
Fantastic. And so just putting a bow on this slide again, confidential information, that's something you're going to want to make sure you protect it in your employment agreement with your loan officers and all your employees, because they're often all going to have access to some measure of important confidential information pertaining to your customers and pertaining to your business systems, processes, business plans, things like that. Confidential information clauses, you guys probably see them in contracts that you look at for various things. A lot of times are huge paragraphs, one huge paragraph. Sometimes I've seen ones that have extended 3 or 4 pages, just the confidentiality provision. To me, those are less likely to actually be enforced. I call them kitchen sink provisions. So when everything's confidential, nothing's really confidential. And so this is another area where, especially if you're working with an attorney or you're working with an advisor in some capacity, think through what's really important, what's really confidential to your business, to your functioning, to your operations, to your growth strategies. And let's identify those in there and make sure those are the things we're really going to, take a firm stance on protecting. Because again, if you narrowly define and properly define what is confidential, and someone walks out the door with it, or someone misappropriates it and uses it improperly, again, that's a lot easier to enforce than if you have a 2, 3, 4 page confidentiality clause that even a court is going to have a hard time saying, well, what's really confidential in here. And so again, I'm a big believer in proactive effort and energy on a lot of these things. And so the more you can do on the front, that's why I love this topic of this webinar series. And so glad that you guys are attending, because the more you put into it up front, the smoother sailing you're going to have once your business is operational in year 1, 2, 3, 5, 10. you're not going to have some of these headaches down the road. So let's pivot to policies and procedures for your business. So here I identified 4 that I always classify as required policies. When I say required policies, I mean these are required by law for you to have them in place. And they're required to be in writing. And especially this first one we're going to talk about, the loan officer compensation policy, is it's one that in small, especially small broker shops, it's a little bit nonsensical, to be fair about it. But you're required to have a written compensation policy, even if it's just you, and you're the only employee, the only loan officer. If you're a true solo, you still need to have a written compensation policy, and you need to have an agreement between your company and yourself. And so if you don't have that, you're technically not in compliance with the compensation rule. It's not something that needs to be overly complex. It should be very specific to your situation and narrowly tailored. All policies that you have should be narrowly tailored to your business. But that's something that, again, I see solo broker owners often overlook or think they don't need to comply with because it's just them. Why do I need to have a policy with myself? But again, technically speaking, you do. When you do have multiple loan officers, obviously it becomes more important that you have a policy in place there. The policy itself is really your outline of how your business is paying your LOs, and that can be very broad. I'm happy to answer questions about different compensation strategies, but you'll want your policy to address lender paid compensation, borrower paid compensation, whether there's a difference between the two, under what circumstances compensation can be changed by the company or by the employee, how frequently that can happen. The fact that your company will not be accepting or paying compensation from 2 sources, because that's prohibited under the rule. The LO comp policy is where I personally like to include your anti-steering policy. It makes sense there because it's very tied to compensation, in my view. And so having anti-steering provisions in your loan officer compensation policy is important. And then, record retention as well is something you want in that policy, because you are required under federal law to retain all records relating to compensation of your loan officers for at least 3 years. We'll touch on record retention, I think, on the next slide a little bit in a more broad sense, but these are kind of the components you think about with your loan officer compensation policy. I'm going to reference this with regard to each of these, actually, but you can get policies in many different places in 2023. They're all over the internet. You can probably ask your friends for examples or copies. You really want to put some time and energy and thought into drafting one for your business and making sure it's specific to your business. You kind of chuckle when you say this or when you hear this, but I can't tell you the number of times that I've talked to people who've had an examiner looking at their policies going, when did you change your business name from ABC Mortgage to XYZ, blah, blah, blah. And sometimes it's not even a mortgage company. It's because people pull stuff off the internet and don't even read it and don't even, bother to document search all the references to the company name. And that can get you in, it can be embarrassing to say the least if a regulator finds it. It can get you in a little bit of warm water with a regulator. Most of them aren't going to come down extremely hard on you if you're not doing other things improperly, but you do want these policies to be narrowly tailored. And for small businesses, for small mortgage broker companies, you want it to be scoped and sized properly as well. So I've seen LO comp policies that are 25 pages long. I've seen AML policies that are 75 pages long. I mean, it's wildly unnecessary. That's what you're going to get from some of the document mills, and that's okay. Trust me, they didn't miss anything in there, most likely, but it's not tailored to your business. You're not going to really be able to follow everything in there because it's not how you operate. By way of example, the LO comp policies that I produce for clients are 5 pages long on average. The LO comp agreements, which include employment agreement provisions, are 7 pages long. My AML policy is 11 pages long, and my privacy safeguards policy is 6 pages long. These are perfectly compliant policies that have been tested through examinations in multiple states. And so I only say that not because I'm so awesome or I'm so great. There's, 100 mortgage attorneys who do tremendous work as well, and they can probably tell you the same thing. It's just, I just use this to highlight the fact that narrowly tailoring these to your business makes sense for you. It's really what the regulators instructing you to do and what they want you to do. And it's just easier to follow. So you don't have to have these voluminous policies that nobody's ever going to read. The other piece of it is the loan officer compensation agreements. You do have to have individual written agreements with all of your LOs. Even if you're a solo, you have to have a written agreement with yourself that outlines how you're getting paid on a transactional basis. If you have other employees that are LOs, that's the agreement. I usually piggyback it and make it an employment agreement that includes compensation and employment provisions. So some of the confidentiality provisions, non-solicitation, those kind of things are included there as well. Anti-money laundering is required of mortgage broker companies as well. This has been the case for, wow, probably over a decade now. This is something, again, a lot of these policies, people, especially when the requirement first hit for non-banks, they pulled them from banks. And so you've got just a binder-sized policy that is largely unnecessary for a mortgage broker company. It is important that you understand it, that you read it, that your employees understand it. And so AML requires that you have a designated officer, compliance officer assigned, who's responsible for overseeing the program, responsible for employee training. Some key things to think about and to look at if you're already in business and have an AML policy, or if you're putting one together, you want to make sure that you do designate your officer in there, that you do train your employees. You want to verify where you're conducting business geographically, because there are what's called high intensity financial crime areas and high intensity drug trafficking areas that the federal government agencies spell out, and they change periodically from time to time. But these are things that should be called out within your AML policy, and you want that to be tailored to where you're actually doing business. And that's something that can change, especially as you expand, if you go into other states or into other territories. So that's something to look at, something to talk to, again, your legal advisor about, or at least to just have a working knowledge and functional awareness of. A lot of information out there. You can hit me up. I can share you the links for the federal agencies that will tell you more about that if you're interested. Fraud and ID theft red flags. This has been a required policy for quite a long time now. I want to say probably more than 15 years at least. It's wildly overlooked. Very few clients I work with have one of these in place or even know it exists. This is not one that most state regulators even flag anymore to look at, but technically it's still required that you have it in place. It's really a know your customer based rule and policy that you're following here. They're not telling you have to be bartenders or cops and being able to spot fake IDs, but it's making sure your employees that are collecting consumer information understand that they know who they're dealing with, that it's a fraud prevention mechanism. And there is some overlap with the anti-money laundering and the ID theft red flags and the GLBA privacy policies, but they all have their own nuanced pieces, and technically they're each individually required. So you do need to have those in place and have an understanding of what that means, and really, if you're building out a staff, to make sure your employees are educated on what they mean. And again, we'll talk more about you've probably heard countless times the terms the compliance management system or a culture of compliance. Those are things we're gonna dive deeper into conceptually in part 3 of this webinar series. But as you're operating your business, those are things that you want to be mindful of. And how do I keep training my employees, keep them up to speed on these things, keep these things fresh in their mind? Because when everybody gets into the day-to-day grind of doing business, of making loans, processing loans, whatever the case may be, sometimes these things can slip. And so having, whether it's a lunch and learn, a coffee thing, having somebody like me come bore your staff for 35 minutes or 45 minutes once a month or once a quarter, there are different ways that you can make sure that everybody's on the same page, and it's really ultimately doing things that will protect your business in the long run. And lastly, the safeguards policy. This is something that's relatively new compared to the other 3 in terms of a requirement that you need to have. Again, not all states that I have clients in are asking to see this. Some are. And so it's important to be aware of it. You do need to have a designated qualified individual, is the term, under the GLBA policy. It's a compliance. It's a control person in charge of compliance for this. Again, it can be the same person as your AML officer. But this policy the key provisions here are really addressing the physical safeguarding of consumer information as well as the digital safeguarding of consumer information. And as mortgage companies, you know, you're going to have some of both. We still do deal with paper, you know, for the time being at least. And there's also a component of your monitoring your service provider relationships, any third parties that might be gaining access to your consumer data, whether that's, you know, and we're going to talk about this a little bit later, like your software companies, your LOS, your CRM. There are different companies that are going to have access to this data. So you are going to have some measure of responsibility for reviewing and verifying that their privacy protections are adequate under GLBA and under your safeguards policy. Also, so those are the legally under the law required policies. As you go into different states, you'll see some states have state specific things that might need to be required, and some states, while not written down as a requirement, will ask for copies of different policies that you'll need to provide in the course of an examination. And so that's something to be aware of as you grow and expand. Additional policies that I'm going to highlight here that I classify as highly recommended but not legally required. I'm going to say not legally required, but these are, in my view, pretty much required for a well-functioning, you know, compliant, safely operating mortgage company. Having a QC policy is important. Again, it doesn't have to be hugely detailed, but some states do require this, and you having a sense of, you know, reviewing and making sure that your files are in order. It's a best practice, at least, because whenever you get examined, the regulator is going to look at your loan files. Inevitably, something's going to be missing from one of them or two of them, and the regulator always asks for those files. It's nothing intentional. Usually, it's nothing malicious. Sometimes it's an oversight. Sometimes something just fell out. Sometimes something didn't get attached. There's almost always a simple explanation. But if you have a QC policy and you actually undertake some QC testing on a semi-regular basis, it will help mitigate some of those things. Now, I'm not impractical. Small broker companies are not going to undertake monthly or even quarterly QC testing for the most part. You can do it. Some do. And there are third parties that you can hire to come in and do that as well. You have to decide for yourself from a business model standpoint, from a cost effectiveness standpoint, is that something that you ought to do? But putting a policy in place at least gives you the guidance and the guidelines to say, okay, this is how we intend to monitor the quality of our files. Advertising is a huge one, and we're going to do a deeper dive on advertising in part 3 because there's a lot that we can talk about there, and it would take up most of the rest of our time if we did it today. But having an advertising policy in place is a good idea across the board, especially if you're growing your company, you have multiple LOs that are out there trying to generate their own business. But even if you're starting out and it's just you, the response I get from a lot of clients I work with, especially, you know, solos or people that are just starting out, it's like, well, I'm not doing any advertising, so I don't need an advertising policy. You're advertising. Trust me. Even if you're not intending to do advertising or what you think is advertising, you have advertising material, advertising collateral that under state and federal law you have to maintain record of, and that you need to, you know, you are responsible for. And so it can be, and I'm not going to go too deep, but I mean, everything from business cards, websites, social media pages, and social media posts. It can be, it runs the gamut. And so putting a policy in place is a good idea because, again, like the QC policy, it's your roadmap. It's to say, this is how I'm intending today. And you can always amend these things as your business evolves and grows. But this is how I'm intending to approach the marketing, promotion, advertising of my business, how I'm intending to go out and get clients. And it's mostly an exercise for you guys as business owners to outline, okay, this is my expectation. When you don't do that, and then you start to hire LOs, they're all out there just trying to, you know, eat what they can kill, and for pick your metaphor. But you want to have that in place so that everyone understands, no, this is what we expect. These are the baselines that are required, whether you're using business cards, social media, you know, these are our brand guidelines so that you know your company is out there and being portrayed in a professional way, the way that you want. So think hard about an advertising policy. Ask around about, you know, different people's approaches to advertising. Get some legal help if you need it. But advertising is one of those highly recommended, quasi-required policies for functional compliant businesses. A larger record retention policy is something that I'm going to say is recommended to a degree here. Record retention is funny, and I take it maybe a unique approach. I don't know that I know that everyone doesn't agree with me on this. My view on record retention is if you are doing it right and you are operating a compliant business with the technology that we have, the digital storage capacities just continuing to grow exponentially, there's no reason for you not to retain your records indefinitely. It can only help you if you're operating in a compliant way. And I say that because, two big reasons. Number one, under different statutes, state and federal, you have different time periods that you have to retain different records. One example is compensation records are 3 years. Advertising records in Florida are 2. If you go to another state, advertising records might be 3, might be 4. And so if you just say, I'm going to keep everything, digitize it, keep everything in, remote storage, whatever, cloud storage permanently, you have it and you're going to be in compliance. Second, the statute of limitations on some of these statutes that you are responsible for complying with, and some that include private rights of action from consumers, extend far beyond document retention periods. So if you are strictly following the statutory document retention period and something goes wrong with a loan, or a borrower comes back on you, or a lender comes back on you, and you've destroyed the evidence that you complied with the law, or that you did it right, or that it wasn't your responsibility, it was really the lender's responsibility. If that's gone, you're going to have a lot harder time defending yourself. And you might have exposed yourself to liability that you could have otherwise avoided by being very vigilant about destroying your documentation. So that's why my advice, again, this is a personal decision for everybody. My advice is to retain your records indefinitely. I think it's extremely, as long as you can do it securely and cost effectively, it's extremely prudent in my view. Now, again, full disclosure, if you're playing fast and loose with the rules, if you don't really care about compliance, you're being wildly reckless, then there's just going to be more evidence of your non-compliance. You still have to retain them for a period of time under the statute, but be that as it may. So finally, a complaint resolution policy is something that I would say is extremely recommended. It is, again, I'm not aware of anywhere that it's legally required, but regulators are looking for this, especially if there's an issue and a complaint gets filed. You want this internally so that you know that you followed the same procedure in responding to a consumer complaint each time. If you treat different consumers who complain differently, that can open up even more problems than the underlying complaint maybe did for you. So there's a consistency element of having a policy and following it. But regulators who get complaints about you will first come and say, did you know that did this consumer complain to you, and do you have a policy, and how did you follow it? And if you're like, yeah, they called me and we tried to call them back, but we don't have a policy, that's not going to play well with the regulator, and you could open the door to more problems, a more detailed examination than you may want. It's just something that if you have that in place, again, being proactive, thinking about it ahead of time, it can help put something to rest and more efficiently and more productively for your company. So I'll pause again because we talked quite a bit about policies there, and give everyone a chance if they want to jump in, and otherwise we'll keep plowing ahead.
There's nothing in the chat yet, but I had a couple questions for you in regards to the LO comp agreement. Within that body of the agreement, do you suggest, kind of going back to the way that LOs are paid, do you suggest that be detailed in the agreement? They're 100% outside sales or 100% sales. That should be specifically mentioned there to kind of cover everyone's bases?
100%. That's a fantastic question. I'm glad you brought that up. You absolutely want to document in that agreement the classification of the LO as a W-2 employee that is exempt under the, for example, might be exempt under the outside sales exemption, and spell out in that agreement some of the detailed requirements for them to satisfy that exemption, so that then they're really contractually obligated to behave that way and to continue to function that way. And if they don't, you're still going to be liable for the misclassification if they aren't following it, but you
Right.
may have recourse against the employee for breaching the agreement if you structure the agreement properly.
Okay. And so additionally, from your last slide here, advertising clause should be there as well, meaning that should that be outlined on what they should be advertising on behalf of, with the company's name and so forth?
Yeah, I wouldn't put that into their comp agreement or their employment
Okay.
agreement. I think
Okay,
what I would typically do is reference a requirement to follow all company policies in that agreement, and then
Okay.
make sure that they're provided a copy of the advertising policy. One thing you can do, so as a best practice, when they're signing their comp agreement, I usually recommend that they check a box or attest that they received a copy of the compensation policy from the company. You can add other policies to that too, to verify that, make them check that and sign off that, yes, I received the LO comp policy. Yes, I received a copy of the AML policy. Yes, I received a copy of the advertising policy. Those are the way I would handle it. I wouldn't put, all of the requirements in the contract itself, because your LO comp agreements will be changed more frequently than your advertising policy should be. So just keeping that static it's an efficiency thing for me.
all right, well, speaking of that, so should the LO agreements then be reviewed annually or re-executed annually, or what time frame do you suggest?
Yeah, I don't personally feel the need to re-execute them on any regular interval. Re-examining them whenever comp's changing, and so that's my recommendation. If somebody's going to stay on the same comp plan and nothing's going to change, there's not really a need, unless something changes from a regulatory perspective, to go in there. And it can be, there's an old, in like government affairs and legislative regulatory world, there's an old, adage about, you don't open up a statute or regulation because unless you really need to, because anything can get thrown in or taken out, stuff you like even. And so when you
Right.
start to renegotiate an agreement with an employee, that could make them, you don't know what's bothering them. You don't know what they're thinking about. It could prompt them to ask about who knows what. And so you need to have a compelling reason to go in there, in my opinion. Usually it's changing the comp plan. And some people opt for, if they change their comp plans on a semi-regular basis. So if they let it, ebb and flow annually or semi-annually, or anything more frequently than quarterly is a recipe for disaster. But I've seen quarterly, and that's, I think, technically compliant usually, depending on how they do it. But then you might want to think about just having the specific comp plan as an addendum to the contract. So then you're just changing addendums out and you're not actually amending the contract. But either way is functional. You can revisit, review the contract when comp changes and keep it in the contract, or you can do addendums if it's going to be a fairly frequent activity.
All right, and then that just brings me to another question. So including, again, of the loan officer agreement. So the non-compete should be in the loan
Yes.
officer compensation as well? Okay.
Yes.
All right.
Yes. I mean, you can do it. Like I've seen it done by some companies where technically the compensation agreement is separate from the employment agreement, or
Mhm.
they tag on a separate non-compete agreement. I think it's unnecessary to do unless you don't. So again, always an exception in circumstances where you have a comp agreement and you want to add a non-compete and not open up the comp agreement, then you just have them sign a secondary document. But if you're coming at this and you're starting your company, or you're just hiring LOs for the first time, just keep it all in one document. It's cleaner. The employee is going to appreciate that. They're not going to have to keep track of multiple forms and documents. And then you know when something changes, you just have to go back to that one.
Right. Okay. All right. I don't
Cool.
see any questions in the chat, so moving along.
All right. Thanks, Linda.
You're welcome.
So we will move on to the next topic, which is reviewing and negotiating broker agreements. This one is something that comes up very frequently in my conversations with brokers, clients, and just brokers that I interact with. Broker agreements they're tough to read, and there's a lot of commonality, but there's a lot of unique specificity across the different wholesale lenders, and so it can be a lot to digest, especially if you're signing up with quite a few of them all at once. So as a starting point, I always say you want to be selective with the wholesale lenders that you work with. You don't want to take a scattershot approach, in my opinion. Again, this is a business decision you have to decide for yourself. But there are strategic advantages, there are practical advantages to having stronger relationships, maybe with a fewer number of wholesalers. You can get better pricing if you send volume different places. You get familiar with your AEs, you're comfortable with technology, you're comfortable with the personnel you're working with. So I say be selective when you're picking your wholesale partners. Not all wholesale partners are created equally, as you guys all know. All of them offer very, very strong things, and all of them have their weaknesses. So you got to figure out what works best for you, who you want to work with, and make sure that it's a good fit. You also want to make sure that you can live with the terms of the broker agreement that's being put in front of you, because they will be slightly different from lender to lender. Maybe you'll find one or two that look exactly the same, but I've read enough of them to know that there's almost always something subtly adjusted, because people like me that are sitting in these wholesale lenders offices, lawyers are always very territorial. We always have to put our own little spin on things, and so our own interpretation. So that's something to be aware of. But again, I say be selective, but cover your bases. As a business owner and as a mortgage broker, you want to make sure that you've got a full menu of options to serve your clients, to serve your borrowers. And you may not have an appetite to do something like reverse or commercial. I just put those on there for example purposes. But it's worth exploring at least partnerships with lenders who can provide these solutions to you from a funding standpoint. And lastly, I always say don't be afraid to ask questions of your future wholesale partners or your current wholesale partners if you're already in business, and negotiate terms. There's a huge belief in the broker community that these broker agreements are non-negotiable, and that belief isn't completely misplaced. They are largely non-negotiable. Most of the lenders will tell most brokers they're non-negotiable, but the reality is, if you approach a negotiation or even a question that you have about certain provisions productively with the lender, they want to be your partner. They're going to, at least for the most part, engage with you, explain why it is a certain way, have a conversation about why they won't change it. But again, you'd be surprised at the flexibility that does exist with regard to some narrow changes within these agreements. Some of it, in fairness, depends on your track record as an LO. If you are somebody who might be starting up your own shop but has a long history of being a high producing LO, you're going to be more attractive, quite frankly, to a lender in terms of being willing to negotiate, because they're going to feel like they're going to get volume return. But these are business specific things, but just don't be afraid to ask questions and negotiate. Don't be intimidated by these contracts. When you're reviewing these agreements and when you're negotiating them, there's several key provisions to pay attention to. Always read the whole thing. Something hugely important can be buried in an innocuous section, unintentionally. I will say I'll give everyone the benefit of the doubt. But I also have seen instances where lawyers intentionally bury something in a section that they don't think is going to be as highly scrutinized. So it's important to read the whole agreement. It's important to read all of your agreements so you understand, your exposure and your responsibilities relative to each of these lenders, because they're going to be different. If you have an attorney that you work with, if you have a legal advisor, that person is going to be a huge resource here for you, because these are they're long agreements, they're thick. There's usually addenda to them. Sometimes there's other attachments and forms. It's worth asking your attorney to help. If you have an attorney that's not in the mortgage space, they will still be very helpful in looking through this, because they will know what to look for. But this is one of those areas where, unfortunately, I don't want to disparage anybody, and I won't, but I hear it from clients all the time. They're like, our local attorney in our small town does real estate law. He's been working with us forever. But I'm starting to worry that he doesn't understand or she doesn't understand the nuances of these broker agreements. Well, he or she doesn't, because they don't read them every day, and they may not have read any of them. and they don't particularly understand that piece of the industry, especially if they're in real estate or they just do, small business, commercial, corporate law. So trying to find an attorney that specializes in the mortgage space is worthwhile. There are, like I said before, there's a number of tremendous ones that you have access to, and with the internet, that we're not hard to find. And so there will be someone that you have a comfort level with. There'll be someone that will be in a geography that you're comfortable with, at a price point that you're comfortable with. And so you just do some research, ask FAMP. FAMP is a great network. Use the FAMP member portal. I think it's on Facebook, the member group, just to share information, to say, hey, does anybody have a good recommendation? So leverage your networks, but this is an area where having the right advisor in place, much like insurance, really helps, because somebody that knows what they're talking about is going to save you a lot of time and a lot of hassle. But I digress. Key provisions to pay close attention to. I got them highlighted here, and we'll talk in a little bit of detail about some of these, and then in a little bit more on the next slide too. But your early payoff and your early payment default penalties, these are going to vary from lender to lender, and they're going to be different. You want to be aware of what they are. I've seen everything from 120 days to 180 days. And so the length of time is something to be aware of. Most of the time, these are very unbroker friendly. They're very just, if this thing pays off or defaults for any reason whatsoever early, the broker is going to be on the hook in some form or fashion. How you're on the hook will depend on the details of some of these other provisions. But this is one you just mostly want to be aware of. It doesn't hurt to question or push back on the length of time. So if you see one that's 180 days or more, go ahead and ask, say, can this be 120? This seems unreasonable. And see what they say. The worst they're going to say is no, but it's something that you can evaluate. And again, when you're shopping wholesale lenders and you're holding these agreements up to one another, that may or may not influence your decision to work with a particular lender, but it could be a factor. The other piece to think about here is, if you're going to bravely negotiate with the wholesale lender about some of these provisions, you want to take responsibility for things that are within your control. You generally would like to disclaim responsibility for things that are outside of your control. The lenders, by default, generally speaking, almost universally are putting everything on you, whether it's in your control or not. This is an area that I, on behalf of clients, push back with lenders on and say, hey, this thing paid off because they won the lottery. What's the broker supposed to do? Are you really going to penalize them for that? So I always try to work with clients and with their lender partners to say, can we insert some type of language in here that just makes it more reasonable for the broker? So if it's something within the broker's control, obviously, if it pays off early because the broker went out and refinanced it, that's something that I think is fair for the broker to be responsible. But that's something you'll hear me talk about with regard to some of these other ones too, is broker control, broker knowledge is another piece of it. So buyback and indemnity provisions, you can see these in a couple different ways. Buybacks are, I would say, falling more out of favor in favor of just indemnity provisions, or at least an option for a lender's option to be indemnified. Lenders they're practical. They understand that a broker is in no position to actually take the note back. And I'm not saying that never happens, but that's usually going to put a broker out of business. And the broker is going to be scrambling to figure out what they do. They're not licensed to service that. They're not equipped to service it or to sell a potentially damaged note on any sort of secondary market. And so lenders realize that they're in a better position to actually dispose of that, whether it's through foreclosure or otherwise. And so you're seeing a shift toward indemnity provisions. And when I say indemnity, it just means, hey, if something goes wrong with this note, broker, you're going to be responsible for making us, the lender, whole. We might choose to hold on to the note and dispose of it through foreclosure or whatever, but you're still going to make us whole through that process. So it's just, these are provisions to read, to understand, to be aware of, to know the circumstances under which you have exposure, because they're going to be broad, and it's going to be very, like I said, broker unfriendly. But you still want to read them and understand what it means and what it could mean. I personally I'm a fan of the shift toward indemnity, because if you have the right combination potentially of insurance coverage, and assets, you can survive. You can stay in business more easily if you're just indemnifying the lender with money. If somebody's going to drop a note or more than one note on your doorstep, so to speak, there aren't many brokers I know that would be able to withstand that from a business operations standpoint, and so you're kind of stuck. So another piece is the reps and warranties. Representations and warranties are huge. These are promises that you're making. Usually, these provisions are promises you're making when you sign the document to be true, and also promises like you're prospectively promising that things will be true about each loan that you submit to that lender. And so you want to read these, and you want to know what you're promising and what you're guaranteeing essentially to that lender. Standard of care is not a term you're going to see in any of these agreements. Unfortunately, nor is the word knowledge in most agreements. But knowledge is one that I work very hard with my clients to try to negotiate into several strategic provisions of these agreements, because I believe fundamental fairness dictates that a broker ought not be responsible for things that he or she has no control of or no knowledge of happening, or couldn't have had any knowledge of happening. Obviously, lenders disagree. They want to shift all the responsibility to the broker, and I totally get that. This is not a contentious thing. It's just, if you have the opportunity to try to negotiate these things, there are strategic provisions, and I'm going to highlight a couple examples on the next slide, where inserting a knowledge standard is very helpful, and it may not seem like it, but can really significantly moderate your risk exposure. Solicitation of borrowers is another provision you want to look at very, very carefully. This varies widely from agreement to agreement that I've looked at. And there's a couple components to this. It's, we've seen, and, got a lot of press in recent years about wholesale lenders that have retail divisions that maybe are, the lender itself is in some way, shape, or form soliciting a wholesale borrower for their refinance or another purchase or something through their retail division. So that's one piece. But the other piece of it is your solicitation of borrowers. You want to read these sections carefully. I've seen agreements where, that have tried to prohibit a broker from soliciting any business that the lender had closed in the previous 12 months, whether the broker had anything to do with that business or not. Again, you would have no knowledge of this. You would only find out after you solicited the business, which would put you in breach of the contract. It's an entirely unreasonable position. I personally believe it's an oversight by the lender's counsel, in terms that's probably not what they meant, but it's in there. And so it's something, this is why you really want to read these closely. Ideally, get legal advice if you can when you're reviewing these, because it's little things like that that can usually be fixed or negotiated out, or might influence your decision to work with a particular lender. Data collection and use of that data. You're sharing a ton of information about the borrowers, the business that you're generating with the lender, necessarily to close the loan. But you're also sharing a ton of information about your business with the lender. Generally speaking, these lenders are asking for a lot of business information about you as one of their partners. And so their agreement should speak to their level of data security, how they protect both your data and your customer data, and what they can and will use that data for, and who they might share it with. Whether they'll share it with subsidiaries of theirs, whether they'll share it with third parties, whether they'll aggregate it and share it, how they're going to use it. These are provisions that, again, not necessarily something you need or want to negotiate over, or that you'll be able to negotiate, but it's something to be aware of when you're assessing these agreements and your relationship with different wholesale lenders, because more and more we see data is valuable, and people are finding new ways to use and exploit data. And so you want to protect yours to the greatest extent possible. Indemnification and third party liability. So you probably see indemnification clauses in most of the contracts that you execute. What this is speaking to in a general sense isn't the indemnity provision relative to a buyback or an EPO or anything like that. This is indemnity that relative to a third party, the borrower maybe another third party that has a claim against the lender. So what you want to do is limit your responsibility to indemnify the lender to claims that arise based on your behavior, based on something you did, an error, an omission, or an act, or something of yours that caused that claim to ripen. You don't ideally want to be accepting an indemnification provision where you're responsible for any of the lender's liability to any third party having anything to do with the loan, whether you knew about it, had control above it, had any, I mean, that there are provisions that I've seen where if the lender gets sued for any reason by anyone in the world, and it is even remotely tied to one of the loans you sent them, the broker's responsible. Again, from where I sit, I work primarily with independent brokers. That's unreasonable. It's not particularly fair. And it's something worth at least asking and trying to negotiate some measure of reasonableness, broker knowledge, broker control, something about that claim where there's a more of a tangible relationship between the broker and the claim against the lender. And dispute resolution is the last one here that I'll highlight. This is one that you also want to look at, and it may not be negotiable. Most entities, lenders in this case, feel very strongly about their dispute resolution provisions. And when I talk dispute resolution, part of this is choice of law, what state law is going to govern this relationship. It's usually the state where the lender is headquartered. That's not something they're likely to change, nor would I recommend trying to negotiate that, because it would be unreasonable to ask them to change that when they've got agreements all over the country. That would be unmanageable on their part. Where you litigate the claim, the physical location is another part. So the venue, that is also likely to be in the state, in the county, in the jurisdiction where the lender's headquartered. That is not as critical as the choice of law, but again, the lender is going to want to keep things on its home turf because its in-house attorneys and its outside counsel are going to have relationships there. They're going to know the procedure. They're going to know the judges. It's a home field advantage thing. Again, unlikely to be negotiable, but it's something to just be aware of when you're signing these agreements, because you as a broker with multiple lender relationships are likely going to have venue and choice of law provisions that require you to essentially stay in some measure of compliance or understanding with Michigan law, New Jersey law, New York law, California law, Texas law, as the case may be. And so again, you're not in a position as a broker, if I'm going to be frank about it, to negotiate away those provisions, generally speaking, but it's something to be mindful of. The bigger piece of dispute resolution, which again, it's unlikely that lenders will budge on this, but it's worth asking, is if they have mandatory arbitration. If arbitration is the only exclusive remedy available to you for any type of a breach, any type of a disagreement or problem under the agreement or with your relationship, that's a big problem for me. I do not like arbitration. Arbitration has I think an unfair, favorable reputation for some reason. It is usually vastly more costly than litigation. It is usually more complex than litigation to follow the rules, and the end result, except in situations where you have a very highly specialized dispute, whether it's highly technical industry or very, very specific dispute that you need somebody that's really an expert to understand the issues, you're better off in court. So I always advise clients, let's try to keep arbitration provisions out of our agreements whenever possible. Let's always ask to get rid of them, or at least give the option. Let arbitration be an option, and if the party that's initiating it wants to do that, that's more reasonable. But let's at least leave open the door to settle something in court, because some of these things, even if it rises to the level of a court action, might be disposable in small claims court, where your costs and expenses can be very, very minimal, or you might even be able to handle it yourself. I wouldn't necessarily recommend that, but you might even be able to handle it yourself pro se without legal representation. And so it just gives you options. and it's something that is very much worth asking about. If you see a mandatory arbitration provision, consider pushing back and just requesting either removing it or shifting it to an either or arbitration or traditional litigation. So those are kind of the key areas within the agreement that you want to focus on. Here's some examples I've literally have pulled from agreements, just to highlight what I'm talking about and maybe hopefully crystallize some of the points. So you see the first one, all representations with respect to the loan application are true and correct. All right, that seems reasonable on its face, but that representation is a promise that everything you send is correct, even if you had no ability to control it, no knowledge of it. If the borrower lied to you and you couldn't possibly have known that something was off, that's why this is an example of an area that I try to work with clients to insert to the best of the broker's knowledge, or to the broker's knowledge and belief, sincere knowledge and belief. You know, whatever the case may be, there's a million ways to word almost anything. If you approach the lender and ideally their counsel with some thoughtful, strategic, targeted requests, you might be surprised at the reception you get. At the very least, they may give you credit for trying, even if they don't change anything. So another example, like warranties regarding submission of accurate, inaccurate information. So we talked about reps and warranties as a section you want to focus on when you're reviewing the agreement. Again, all information provided by each applicant and the broker in such applications are true and correct. Again, here's another one. To the best of the broker's knowledge and belief is something I would try to insert there, because you're warranting to the lender, you're promising to the lender here that everything you submit is true, even if you have no way of verifying that. So here's another one. Broker is responsible for all actions of the applicant and any third party involved in the loan process. This is insane. I mean, it's just, this is crazy. It's in a lot of agreements. Not this specific verbiage, but this did actually come from an agreement. But it's there in substance in a lot of the agreements that I look at. This is worth pushing back on. Again, you might not, and maybe likely won't even get this changed or softened. But you want to make the case that the broker has absolutely no control over the applicant in any legal sense, in any meaningful sense, in any practical sense, and really doesn't have any control over any third parties involved in the transaction unless they're an affiliate or a subsidiary of the broker themselves. And so it is again unreasonable in my view, as generally a representative of the broker, to put that much responsibility on the broker. At some point, you know, every party needs to be responsible for themselves, and if the lender has an issue with a third party, they should take it to the third party, not go straight through the broker. And I know why the lenders put this in there. It's not unconscionable of them to do. I understand their perspective, but I think it's fair for brokers to push back. And then here's an example of that overly broad indemnification provision I mentioned on the previous slide. Any claim asserted by an applicant or a borrower related to a mortgage loan originated by the broker. That's what in one agreement the broker was indemnifying the lender against. Any claim that anybody raises against the lender. So you see in the red there, what I recommend, what I encourage us to put in there, try to negotiate in there, is based upon an action or omission of the broker and related to the mortgage loan originated by the broker. If the broker does something, if you guys do something that, you know, you make a mistake, that happens. It's, you know, that's reasonable to own up to your mistakes, but to indemnify the lender against a claim from the borrower based on something the broker didn't do and had no responsibility for is a bridge too far. The lender is going to say, most likely, you know what, the only reason that borrower can sue us is because you brought us that borrower, so it's your fault. Okay, I get it, but again, we're talking about provisions that are worth at least asking the question about, trying to negotiate and see if you can soften some of your liability exposure with at least with some of your relationships. So I'll pause again there as we shift from broker agreements to what's going to be our last, you know, substantive topic. I think we're great on time, and we'll touch on technology agreements if we don't have any broker agreement questions.
No, I think you stumped everyone on that broker agreement. But that was really, really good information, I'll tell you. Really
Well, thank
good.
you. So I'll just dive right in here and we can have some more time for questions at the end then, but understanding technology and
We do
software as
have
a
one
service.
question that just
Okay.
popped up.
Okay.
Okay, regarding broker agreement. The question is, what should you do if you've signed an agreement already? So I'm assuming that if you signed an agreement already, but you want to go back and maybe,
Yep, that's a great
Approach
question.
things.
It's one I get a lot because I don't, not everybody that comes to me as a client is starting up their business. Some of them have been in business for a
Right.
while. And so, generally speaking, depending on the issue you have with the agreement, if it's just sort of the things we talked about here, I would say wait until they ask you to reaffirm the agreement, or wait until they send you a revised agreement or addendum. That happens fairly frequently, where they want you to reattest to it. Just wait till
Certify.
that comes up and let them open the door to the conversation. Then it doesn't look like you were digging around, or that will make them more uneasy if you just come out of the cold and say, I know I've been working with you for years, but I want to talk about this. Like that's a strategic play in my estimation, is just wait for them to bring it. Now, if you reviewed your agreements and there's something that you're like, I can't operate like this, that's different. I mean, if it's like you're scared to death, whatever, that's when you would want to assess either maybe pulling back your business from that lender until you can renegotiate the agreement, or approaching them at that point and just telling them, hey, I'm not going to be able to send you any more business until I get this resolved, because I either I got some information new information, or I took a look at this and I didn't understand it before, whatever the case may be. Just say, I'm really uncomfortable. We need to work through this. That would be kind of the threshold for me, is if if it's keeping you up at night, the liability you feel you're exposed to, then it's worth addressing immediately. If it's more of these soft, hey, let's take a shot at softening some of these things, then I think you probably can wait. It would be more disruptive. It might be more disruptive of your business if it's a lender you work regularly with, to go try to renegotiate that midstream.
Good answer. Thank you.
Okay, good questions. So last thing we're gonna talk about is just understanding the kind of the differences and the nuance between, you got your broker agreements. We've talked about your contracts with your LOs. You're used to you dealing with your commercial lease, different kind of contracts. So these technology and software as a service agreements are somewhat unique animals, but they're things that we're all, dealing with more and more on a regular basis. And these providers are shifting everything to cloud-based. You're not buying hardware anymore. You're not buying even, software that you're downloading. It's you're subscribing to a service. And there's some technicals and some nuances that it's important to think about and be aware of, because these are integral to your business. You're talking about your CRM system, your LOS, could be your email. It could be, if you have eFax, it could be your website. It could be any number of different things. I mean, you see some examples on that image there. So some of the areas within these contracts that I want to emphasize to you to pay close attention to really dissect, to be prepared to negotiate on if need be, are these. So first and foremost, is the provider offering a trial period, a meaningful trial period, or some type of a reasonable cancellation if this doesn't work out for you? This is one where I've seen literally the entire spectrum, where we don't do a trial period. We're so great. You're going to sign up, and oh yeah, you can't cancel without penalty. Don't do that. I mean, just keep shopping around, because invariably that is a sign to me of a company that's not standing by their product, that doesn't have confidence and belief in their product, and they're not going to be a good partner of yours. I've had to have those conversations with some of my clients, because when they get locked in for a year, and they all have their reasons why they lock you in for a period of time, but that to me is really hamstringing a small business mortgage broker in this case. So a meaningful trial period also is not 7 days. You guys are busy. You guys are, even if you're not operational yet, you're still setting up your business. It's really hard to assess whether you like something in a 7-day period. 30 days is pushing it, to be honest with you. I tend to encourage at least a 2 to 3 month trial period or cancellation window. So look and see if that's in there. Just be open to shopping around if you're not finding that from the first or second provider you look at, and ask the question, say, what if this doesn't work out? These are not inexpensive services that you generally speaking sign up for. And, there's a measure of complexity in terms of getting your data converted to some of these things too. So just make sure that there's a reasonable out. Also, in that similar vein, keep a close eye on the contract length. You want to know that there's a identifiable endpoint. And this is where this relates to the cancellation provision. If you're signing up for a 3-year term, and you might be incentivized to do that by getting a lower rate, that's great. But that's a big difference: a 3-year term with no cancellation provision, or a 1-year term with no cancellation provision. So this is where kind of there can be some ebb and flow. If somebody's like, well, we want you to sign a 3-year contract, okay, great. How about you let me get out of this and with 6 months notice, or 9 months notice, or even 12 months notice for a 3 or 5-year contract. But it can be a sliding scale. But you want to look at the cancellation and the contract length together, because those two work hand in hand, and they really dictate your level of exposure. And if those provisions aren't in there, or they're not favorable to you, you can be stuck, negotiating a heavy bill. I had the unfortunate situation of having to help clients get out of some of these, and the only way to do that is work very hard to negotiate down a buyout price, because the company is very firm and fast on not letting people out of their contracts. And so you want to look at these things up front if you can, and try not to get locked in, because litigation is expensive, negotiating a buyout's expensive. It's money that you can spend better elsewhere. Auto renew is another one, especially relative to contract length. If you have a contract that's for 3 years and it's going to auto renew, if you miss the deadline to give notice to terminate, you might be on the hook for 3 more years, whether you want to or not. And so you want to check that closely, and make sure that whenever you're signing a contract, especially a subscription service contract, that if it has an automatic renewal provision, or if it has a date threshold where you have to give notice to terminate, put that in your calendar. You're never going to remember that in 12 months or 24 months, or whenever that time comes up. Put in your calendar so that a reminder pops up that, hey, in 30 days from now, I have a deadline that I have to decide if I'm going to keep using the software. If it's great and you're going to let it renew, you just do. But just be a little bit proactive on that on the front end. But the only way you can do that is if you read the contract and identify, the term and any auto renewal provisions. The ownership and protection of data that you're sharing with this service, that you're housing within their ecosystem, within their cloud environment, is hugely important. And so I think you want to look at that provision very closely, and you want to, make sure it's up to your standards. Make sure that you're comfortable with what they're going to do with your data. Some of them are very, very open. Anything you put in there, they can use either in the aggregate, or just anonymize it and use it even on a case-by-case basis for their own purposes. Some of them will sell it, and they'll tell you that. But again, you got to read the documents closely to know what exactly they're going to do with it and how they're going to protect it. As we mentioned earlier, you as a broker owner are going to have some measure of legal responsibility under different statutes and regulations relative to the consumer data that you are uploading into, for instance, your LOS system. And so if they're not protecting it adequately, you could end up having liability exposure that you did not intend, and that really it is your responsibility, but it is not really your fault. It's the third party that's failing. Limitation on liability provisions. This is another big one. They're going to try to limit it to the greatest extent possible. Usually it is as low as 1 or 2 or 3 months of the fee that you pay them. That's inadequate in my view if they are housing a bunch of your data. So for example, it depends what they're exactly disclaiming, but if you're putting all your data into a CRM and they have a breach and it's lost and you can't retrieve it and it's gone, you have far greater damages than whatever you paid for that monthly subscription or for 3 months of a subscription. And so they ought to be more responsible to you in a financial sense in that situation. They're not going to want to. Most of them won't negotiate this, but it's worth asking. It's worth looking at so you understand, okay, is it 3 months of what I paid? Is it 6 months of what I paid? Is it the aggregate of what I paid for the past 12 months or the entirety of the contract? It's a wide range, but it's important to know, will this company make me whole if they do something wrong or if something catastrophic happens on their end? And again, not disparaging anybody, but companies that are going to provide you with a little bit more balanced agreements, a little fairer provisions, that signals to me that they are more confident in their software and their service and in what they're providing in their security systems. When you push back and they're like, no, we absolutely can't or won't take on any more liability than that's fair. That's their prerogative, but it's something you might want to assess in terms of whether that's somebody you want to do business with, because I personally question, if they're going to stand behind you and if they're really going to be a good partner. And again, dispute resolution, same thing with the broker agreement. Get the mandatory arbitration out of there whenever possible. These guys particularly will want to do mandatory arbitration. They will probably claim that they are so specified and so specific that any dispute is going to be hard for a judge to understand. That's BS. Judges are very capable individuals as a general rule. They see these type of things all the time, and the disputes that you're going to have are very less likely to be highly technical disputes and much more likely to be strictly contractual disputes. And so it's not particularly reasonable in my estimation to have a mandatory arbitration provision. But again, I'm very anti-arbitration, as you can tell. So that brings us to the end of today. Really, this is the same slide we started with, a recap of what we covered. We hit on company and branch licensing, protecting your business with the right insurance network of coverages, some little bit about employees and hiring and classifying them properly, your policies and procedures, your broker agreements, and then these technology agreements. So thankfully, I raced through it, I think, in good and just enough time. If you do have questions, fire them away. I'll do a quick plug for part 3. We're still settling on a date for part 3, and that will, FAMP will get that out to you. If I didn't bore you to death today and you actually want to come back for more torture and punishment sometime in May, in that session, we'll focus on navigating your first year in business. We've kind of taken you hopefully from, the early stages of, do I want to be a business owner, to, okay, how do I get operational in a functional, compliant way? And then now we want to close this series by talking about what can I expect in my first year. And I don't think it's unique to just your first year, but we're going to talk a little deeper on advertising compliance, the requirements to file call reports and other things through the NMLS, and a little bit deeper dive on multi-state licensing questions, preparing for and responding to a letter from an examiner that they're knocking on the door and want to see some files. And like I said earlier, just that general culture of compliance, a compliance management system, what that means as your business grows and evolves. So I'll shut up and take some questions or let you guys steal 5 minutes back of your day.
I don't see any questions at the moment, but that was a lot of great information. And this next series looks even more exciting here. So everything we can cover. Yeah, I didn't really specifically, it's really, for me as a business owner, it's like I really need to go back now and kind of look at those agreements and reread them again, because there's certain things that, we just need to make sure we're aware of, for sure. That's
huge, and I'm glad you said that. A lot of this it's a knowledge piece, and that's where, I know some people walk away, and I talk to parents like, man, you give me homework. I got to go read all these documents. I got to do all this. That's true to a degree, but it's a knowledge piece. Knowledge is power. When you understand what's in your agreements, broker agreements, tech agreements, otherwise, your relationship's going to be better with that partner of yours, and you're going to be able to evaluate your partnerships a little bit more effectively too. Then you're not just basing it on kind of the forward facing things. You're basing it on the substance of the relationship, which is defined in the contract. So
right, exactly. Exactly. Well, we have some thank yous in the chat box, and I will go ahead and go ahead and give people back their last 5 minutes of the day. Thank you very much, Ryan. And as we move forward, we will notify all of you of the third series, and we will also send you out the recorded information today if you'd like that. So with no other further questions, again, Ryan, thank you so very, very much. It was wonderful.
My pleasure. Thanks, everybody.
Bye-bye.